In today's video, I'm going to discuss another important area of law, that is international environmental law. So I'll be covering these areas in this video: historical evolution of environmental law, international environmental conferences, and also the basic principles of environmental law. So let us start with historical evolution. Environmental protection in ancient societies was often rooted in religious or cultural practices. We can see different religions and cultures across the world were advocating for environmental protection and the protection of natural resources. For example, early civilizations like Mesopotamia, India, and China had laws which restricted deforestation, pollution of rivers, and the overuse of natural resources. Another example is the Code of Hammurabi in Babylonia, where they had provisions related to land management. Also, when looking at the records of Sri Lankan history, we can see an important incident which shows us how environmental law principles were advocated even during the 3rd century BC. During this time, King Devanapiyatissa was ruling Sri Lanka, and while he was engaged in his daily hunting, he was stopped by Venerable Arhat Mahinda Thero, who has visited Sri Lanka from India in order to propagate Buddhism in the island. He advised the king, stating, "You may be the king of this country, but you are not the owner of this land. You are its trustee, and you hold this land for the benefit of all those who are entitled to use it, both now and the generations to come." So this statement mentioned in the Mahavamsa, the historical records of Sri Lanka, shows that environmental law principles like intergenerational equity and public trust doctrine have evolved from a very long time back. Moving on, the world faced a severe environmental crisis during the times of Industrial Revolution and after the Second World War. In 1952, The Great Smog of London, and in 1962, Rachel Carson's book Silent Spring, which exposed the dangers of pesticides like DDT, made the world realize the importance of taking action towards the protection of environment. As a result, we can see the establishment of several environmental organizations such as Greenpeace, which was founded in Canada in 1971. Also, the first major international conference on environmental issues was held in 1972 in Stockholm, Sweden, and this led to the passing of Stockholm Declaration, which led to the creation of the United Nations Environment Programme. Let us now look at some important international environmental conferences which were able to bring some positive changes into the international environmental law. In 1972, the UN Conference on the Human Environment was held in Stockholm, Sweden, which resulted in the Stockholm Declaration and the establishment of the United Nations Environment Programme. Next, in 1987, World Commission on Environment and Development was held. This is known for the Brundtland Report, which introduced the concept of sustainable development. And next, in 1992, another important conference was held, which is known as the United Nations Conference on Environment and Development. At that time, it was known as the Earth Summit, but later it was called as the Rio Conference because it was held in Rio de Janeiro in Brazil. This also led to the establishment of the Commission on Sustainable Development and three major agreements, namely the Rio Declaration on Environment and Development, Agenda 21, and the Statement of Forest Principles. Not just that, this conference resulted in two multilateral treaties which were open for signature during the conference. These treaties were United Nations Framework Convention on Climate Change, also known as UNFCCC, and the Convention on Biological Diversity. Moving on, in 1997, the third Conference of Parties under the UNFCCC was held in Kyoto, Japan, which resulted in the adoption of the Kyoto Protocol to the United Nations Framework Convention on Climate Change. Also, 2002 marks an important year where the World Summit on Sustainable Development was held in Johannesburg, South Africa, also known as Rio Plus 10, was used to review the progress in the implementation of the Agenda 21 since its adoption in 1992. Again, this led to the adoption of the Johannesburg Declaration on Sustainable Development and the Plan of Implementation. In 2012, we can find another important conference, that is the UN Conference on Sustainable Development, known as Rio Plus 20. This was held in Rio de Janeiro, Brazil, and this developed a set of sustainable development goals, commonly known as the SDGs. Next, in 2015, the UN Sustainable Development Summit was convened as a high-level plenary meeting of the General Assembly in New York, USA, which adopted the 2030 Agenda for Sustainable Development. Again, in 2015, one of the important conferences which was held is the 21st Conference of Parties to the United Nations Framework Convention on Climate Change in Paris, France, also known as the Paris Climate Change Conference, resulted in the adoption of one of the important agreements on climate change known as the Paris Agreement. We will discuss more points and more information about these agreements in future videos. Now we can look at some of the main principles of environmental law, which were mostly introduced by the different agreements and declarations passed during the international environmental conferences, which we just discussed. So firstly, we have sustainable development, which was recognized in the Rio Declaration on Environment and Development in 1992, and also the Brundtland Report. This ensures that development meets the needs of the present without compromising the ability of future generations to meet their needs. So simply, sustainable development means the law allows development, but we have to ensure that we do not compromise the future generations' ability to use and enjoy the natural resources to meet their needs. And secondly, we have polluter pays principle. According to this principle, those who produce pollution should bear the cost of managing it through reparations or cleanup efforts in order to prevent damage to the environment and to human health. So if you do the damage to the environment, you're responsible to repair it. That is the principle of polluter pays. And next we have the precautionary principle. If there is a risk of severe damage to humans and or the environment, absence of conclusive or definite scientific proof is not a reason for inaction. So this means even if we do not have conclusive scientific proof that certain action is going to cause environmental damage, we have to take precautionary measures. So this promotes proactive measures to prevent environmental degradation. And next we have the prevention principle, which is somewhat similar to the precautionary principle, but there is a subtle difference. Prevention principle requires measures to stop environmental damage from happening, especially in situations where the risks are well understood. So this means if you know the risk, you have to take preventive actions. And if you're not sure about the risk, you have to take precautionary actions. So that is the difference between the precautionary principle and the prevention principle. And fifth principle is intergenerational equity, which advocates for the preservation of natural resources and the environment for the benefit of future generations. Next, we have intragenerational equity. This is the concept of fairness and justice in distribution of resources and opportunities among people of the current generation. So without any discrimination, everyone, every human being is entitled to enjoy and use the natural resources fairly and equally. The seventh principle, known as CBDR or Common but Differentiated Responsibilities, was outlined in the United Nations Framework Convention on Climate Change. This recognizes that all countries have an obligation to address climate change, but developed countries, being historically responsible for most environmental degradation, have greater responsibilities in addressing global environmental issues compared to developing countries. And next we have common heritage of mankind. So certain global commons or resources which do not belong to one particular country, like the high seas and the outer space, these are regarded as shared heritage of all humanity, and they should be preserved for the collective benefit. And lastly, we have environmental justice, which seeks to prevent disproportionate environmental harm to vulnerable communities. When we say vulnerable communities, it includes developing countries and small island nations, and also communities like indigenous communities, low income groups who are disproportionately affected by climate change, and natural disasters. So, environmental justice seeks to prevent this disproportionate environmental harm to vulnerable communities. So, thank you for staying till the end of the video. I hope you gain some knowledge about what is international environmental law. And if you want me to discuss any of these principles in detail, please let me know. And if you enjoy the video, if you learn something from it, please do let me know by liking and commenting or subscribing to my channel. Thank you.